It's an Intel center now.
It's a federal designation, right?
Mm-hmm. Chauncey runs it in the New York, New Jersey hideout.
Chairman, we're live.
Southern District has a pin like that, but it's...
Good morning, everybody.
Excuse me, Chairman, I have a complaint I'd like to serve upon the commission. Thank you.
Good morning, everybody. Let's start with the minutes. We have two sets of minutes. We have minutes from our meeting of November 17th and our meeting from December 15th. Are there any comments or questions about either of those minutes? Let's start with the minutes from November 17th. If there are no comments or questions about the minutes from the public session on November 17th, I'd entertain a motion to adopt those minutes.
So moved.
Is there a second? All in favor of adopting the minutes from the public session from our November 17th meeting, raise your hand. You guys get everybody? Any opposed? Seeing none, the motion is adopted. Now, with respect to the December 15th meeting, are there any comments or questions about the minutes for the public session for that meeting? And if there aren't any, I'll entertain a motion to adopt those minutes.
Seymour Knox.
Commissioner Knox moves.
I'll second.
Commissioner Cavello seconds. All in favor of adopting the minutes, raise your hand from the December 15th meeting. Any opposed? Seeing none, the motion's granted and the minutes are adopted. Let's turn to item 3 on our agenda. We've got some reports from the staff. Who is going to update us on our third quarter financial report, please?
Steve Bowen, our Director of Administration.
Steve, good morning.
Thank you. Good morning, Mr. Chairman. For the third quarter ending December 31st, 2015, personal service was just over $1 million, which for a year-to-date total of just a little over $2.6 million, which is approximately 60% of our cash budget so far. So 3/4 of the year is over with. We have 6% of our dollars spent. For non-personal service, we spent just over $179,000 for a year-to-date total of $575,000, which equates to about 52% of our cash budget. We do have in the pipeline some projects that either have to be paid or are hoped to be expended by April 1, and those total about $190,000 in these special projects. So overall, for this quarter, we spent $1,179,000 for a year-to-date total of $3.2 million, or 58% of our budget. Any questions? Thank you.
All right. Someone's going to give us an update on outreach activities.
Sure. Stacy Hamilton, Special Counsel and Manager of our Education Program.
Thanks, Monica. Commissioners, may remember the last meeting I spoke about the education unit doing an uptick in our outreach activities. I spoke about a survey that we did where we got amazing response on, and the survey was about doing open ethics forums. We had incredible interest. Most people said they were interested in outside activities, so we held an open ethics forum on January 14th on outside activities. We had over 117 registered participants from over 71 different agencies. It went really, really well. We got a lot of great feedback, and we'll be doing more in the future.
Great. Any comments or questions for Stacy? All right. Thank you, Stacy. And someone's going to give us an update on
Sure.
the changes to our website.
As you know, we've been working on redesigning the look and feel of our website, and we have a consultant that we've retained to do that. They are reporting that they expect that we will be able to go live before the next commission meeting. We're moving into the phase, they're going to deliver something to us to review, then we'll do testing, and assuming there are no issues, we would expect to go live before the February meeting, and we can demonstrate the website to the commissioners at the February meeting unless something changes from the testing.
That's great. That's really good news.
Mr. Chairman, I just wanted to mention the New York State Bar Association had reached out to me to invite me to a lecture they're having this Thursday at their conference in Manhattan. And Martin is coming down to speak to them as well.
Great.
He's going to be a member of the panel, and I have every intention of attending.
That's terrific. What's the subject matter of the panel?
Ethics.
Local lobbying.
Oh, that's great. That's really terrific. This is the annual State Bar Association annual convention. It's terrific. Let us know how that goes. All right. I think the staff is going to update us on the governor's proposal in the budget for the items that affect us and the proposals with respect to JCOPE that the governor and the legislature will take up, presumably this session, or at least discuss. So I'm going to turn that over to Monica.
Yeah, I'll just briefly overview so that everyone has an understanding. And of course, if anyone has questions over the next month or so, feel free to give us a call and we can talk you through our understanding of the proposals. First of all, the governor's proposal is to give JCOPE a flat budget, so to continue its existing budget of approximately $5.5 million with the same amount allocated to personal services and non-personal services as was for the 15-16 year. As we'll discuss, there are some proposals, amendments and proposals in the bill. If those were to pass, I would want additional funding in order to accommodate them. So for specifically, one of the big proposals that the governor has is to subject JCOPE to FOIL and to the open meetings law. Both of those proposals are to become effective, if they pass, of course, on January 1st, 2017. So there is a lead-up time for us to get prepared, and I would suggest that we would, if this happens, we would use that lead-up time to staff up and create a FOIL unit. So again, we would need funding and additional staff in order to do that. So I'm in contact with DOB about those requests and what we think we would need in order to meet that, if it happens. In addition, there are several different ethics proposals. This isn't going to be comprehensive, but just some to make sure that you're aware of what they are. Among other things, some of these are responsive to requests and suggestions that JCOPE had in its report it issued last February, as well as suggestions from the review panel that issued its report last fall. In addition to others. And so, for example, one of the proposals is to add penalties to those sections of Public Officers Law, Section 74, that don't currently have penalties. In addition, there's language to add accessorial liability for violations of the Public Officers Law. So for those people under our jurisdiction who don't necessarily violate the law themselves, but assist or aid another or encourage another to violate the law, the language would cover those acts as well, make it clear that we would have jurisdiction to pursue those. Obviously, there are changes to Public Officers Law 73-A, the section in the statute that deals with the financial disclosure statements. Among other proposals, there is a proposed amendment to eliminate the current categories of value. So rather than using a category of value, you would put a specific number when they're asking questions about income or holdings and so forth. There is also, again, some of this comes from our own requests, a proposal to authorize JCOPE to seek supporting documentation when it's doing its random reviews of financial disclosure statements, and authorizes JCOPE to impose penalties for those who fail to cooperate with our efforts. And finally, there are changes in, I'm sorry, not finally, but there are changes in the Lobbying Act that are proposed. One of the most significant is to add a whole new element of disclosure for political consultants. So it basically creates a parallel to lobbyists. Political consultants, as defined in the proposals, would have to file all of the registration and disclosure paperwork that is required, and would be subject to the provisions in the Lobbying Act that prohibit gifts under certain circumstances, that prohibit contingency fees under certain circumstances. So all of those would also apply to political consultants under the proposal. In addition, the proposal includes requiring electronic filing, mandating electronic filing for lobbyists and clients of lobbyists. And as a parallel to the provision we talked about with respect to financial disclosure statements, the proposals include penalties for those who fail to comply with the random audits that we conduct by statute of lobbying filings. So those would have potential penalties up to $10,000. And finally, there are suggested amendments to Executive Law 94 that would change the timing requirements for how fast the commission needs to act on complaints or vote after we've sent a 15-day letter. The current statute says that action must be taken within 45 days. The proposal is to extend that to 60 days. And there's language that's proposed to be added that would expressly authorize the commission to adjourn matters or to defer to ongoing criminal prosecutions. So that's just an overview, but again, if anyone has any questions, happy to entertain them now, or if anyone wants to call after the meeting and discuss them.
All right, thank you.
Monica, would you be so kind to send around the bill, or whatever portion of the bill applies to Jacob?
We definitely could send around the bill to anyone who wants it. It's obviously very lengthy, and there's relevant sections, so we can send something around that helps you get through it and figure out where to look.
Yeah, just the relevant provisions, Secretary Jacob.
All right, thanks, Monica. Let me give, on behalf of the committee, the subcommittee that we put together on our search for the executive director, let me update everybody on where the subcommittee is. And once again, I want to first start by thanking the other members of the subcommittee, Marvin Jacob, Eileen Koretz, Mary Lou Rath, and Michael Rosen. We've reviewed 204 resumes. We've conducted interviews with 13 candidates, and the committee's consensus recommendation is that we present 4 candidates to the full commission for further vetting. The thought being that at some point in the next several weeks, these candidates will make themselves available to as many of the commissioners who would like to attend, either here or in New York, or certainly the candidates will be here or in New York in person, and to the extent that folks would like to either meet the candidates directly or participate by telephone or by WebEx, that we have an opportunity for the full commission to vet these 4 candidates as part of an effort for the full commission to make its decision as to whether or not any of these 4 candidates that we are presenting to the commission should serve as the executive director. We've solicited dates from each of you and dates from the candidates, and we will set up some times, as I said, in the next several weeks for that to happen. We will distribute, if we haven't already done so, we'll distribute the resumes of the 4 candidates to the full commission, so that you have an opportunity to see their curriculum vitae in advance of the meeting. And again, I want to thank the members of the subcommittee. This is taking quite a bit of time, and you have all worked very diligently to try to work toward a consensus solution to our search for the ED. So that's where we are. A discussion to be continued. Unless there are comments or questions on that, we have a number of advisory opinions that we have been considering, and I think the first one on our agenda is an advisory opinion on the Lobbying Act implications in social media activities. I'm going to turn this over to Monica so she can give us an update on the status of the public comments that we have been soliciting.
I'm going to turn over to Associate Counsel Leah Ramos, who's in New York City, to just talk about where we are in developing guidance on the social media as lobbying. Leah?
They need to.
Thank you, Monica. So as we discussed at the December meeting, one of the issues we're looking at in the lobbying context is social media, and specifically when the social media activities constitute lobbying, and what are the reportable costs associated with that social media activity. We've solicited comments and included specific questions that we're considering, and received 3 sets of comments in response from Citizens Union of the City of New York, the New York Advocacy Association, and from a client of Wilson Elser. The comments generally supported the idea that there should be guidance in this area and acknowledged that social media activities could constitute lobbying. However, there were also concerns raised about holding lobbyists or clients of lobbyists responsible for posts made by staff on their personal social media pages, and also holding lobbyists and clients of lobbyists responsible for the actions of others who repost their statements, either by retweeting or reposting. There was also a concern that purely educational social media content could be considered lobbying. The comments cautioned that a social media post should not be considered lobbying unless there's, 1, a call to action, and 2, the poster has actual knowledge that a lobbying target will receive the communication and intended for that to happen. We also received a request for the comment period to be extended, so we're doing that, and the period will be extended to February 19th. We're also going to be holding a roundtable in New York City on February 12th.
Anybody have any comments or questions for Leah?
Yeah, Mr. Chair, when is our next meeting?
2/17.
February 7th.
Wednesday.
Wednesday, February 17th.
Why are we extending the period beyond our next meeting?
So,
We should move this.
Go ahead, Martin. Why don't you-
We're trying to wrap this.
yeah, we're aware of that, Commissioner, and the reason it was scheduled as it was is that the 12th was the best date to host the roundtable, and then we wanted to give folks an opportunity to submit comments after the roundtable discussion, and we felt like a week was an appropriate time to let them put those together. So that was the reason for it.
This opinion is probably one of the best that this commission has drafted. And it would seem that we should act sooner rather than later in this area. So I'm a little surprised that we're just moving it out and not undertaking the duty.
Commissioner, we had a request that we extend the time for public comment, and we're trying to encourage more discussion. So I don't think we're moving it out. We're trying to really engage with the groups that are going to be covered by it and make sure that we understand all the issues. And then, of course, we have to draft something. The next meeting is only 3 weeks away. So, you know, we are extending it beyond the next meeting, but with... Go ahead.
When did we first put this opinion out for comment?
After the last meeting, sir.
Right before the holidays.
Right before the holidays, George.
This is the first instance this has gone public.
Dan, it just seems to me that we should wrap this up before our next meeting and have it before us so we can make a decision on it.
You know, George, I share your concern for, I share your concern for trying to get things done, George, but we have always, when there is a proposal like this, made sure that there's an opportunity for full public comment, and given the fact that these regs, or this is not a reg, I'm sorry, it's an advisory opinion, was for the first time disclosed just before the holidays, it seems to me that we're not being imprudent if we permit the public to comment further. And I agree with you that the staff, I'm glad to hear you compliment the staff on the drafting of this. I concur. But Dawn, I think you had a comment. I'm sorry. Dawn Smalls, did you want to?
Well, starting with a question, which is, do we ever, other than posting it on our website and inviting comments, do we ever specifically reach out to people to comment?
Yes.
The answer is yes, but I'll let Monica.
As we did in the other advisory opinion, which we're going to discuss shortly, we do a lot of outreach and engage with the entities that are regulated by us, both formally and informally. So we don't just post it on our website. We send it around to all the regulated entities. And as we mentioned, we're going to hold a roundtable for some of the new commissioners. What that is that we meet with a group of people in person. It's open invitation to those who are regulated by us to come in and engage in a discussion and bounce ideas off of each other as well as with us in developing this. So there is a lot of back and forth. And again, this is what we did with the other advisory opinion on consulting.
So the reason that I asked that is because, one, we only received 3 comments, and we didn't receive any comments from anyone that is squarely in the technology or social media space. And so if we're putting forward an advisory opinion on the basis that communication is evolving and this is something new and outside of our wheelhouse, it seems at least a missed opportunity to rely on our traditional constituency and not reach out to those who are squarely operating in new tech and the social media space about how they operate and how they might be captured by these rules.
I think that's a good suggestion. I mean, the other thing, George, I want to add to your point is that our next meeting is scheduled for mid-February, which, as Monica said, is only 3 weeks from now. And as you know, the scheduling of our meetings is in large part driven by the individual schedules of the 14 commissioners that sit on the commission. And so ordinarily, we would probably have, a longer period of time between meetings. So the fact that, the staff is proposing a closing of the comment period in the 3rd week of February, would be consistent with a schedule that would ordinarily have us taking up this matter, at the end of the month. But again, because of the way that our schedule, we've designed the schedule based on your needs, professional and personal, it just is playing out this way. So, let me turn to Martin or to Monica and take up Dawn's question about reaching out to those professionals in the tech space on this issue. Is that something that we can do?
Yeah, I think it is. I think your point about reaching out to the tech folks who might be implicated by the opinion, I just want to clarify, the goal is to regulate those who engage in lobbying, and if those are engaged for technology services, that's obviously not the clear intent of whatever opinion we might draft, but we should reach out to get a technical...
If they're engaged in what? No, before that, you gave a counter example that you just faded out for a second, I couldn't.
If they're retained to provide technical services, they probably would not be covered by whatever opinion we draft. I'm not saying they aren't, but your point is well taken, and we can obviously, we can reach out to folks who have more experience in this issue than we do.
Yeah, and I would just offer that there are platforms and organizations that are national and based in New York that are online advocacy organizations that are working on, who almost exclusively function on social media and social media platforms. And I mean, I believe that the way that this is drafted, they would be captured by this. But it also seems like we're drafting a rule without actually engaging. If we're saying that we're trying to adapt to changing times and changing forms of communication, to not actually directly engage the people who are squarely in that space and at the forefront of how this is being used and the changing technology, we may miss the boat by not doing that on the forefront. And then the second half would be that there are a series of organizations that may not be on your on our radar because they're not brick and mortar, because social media has not been squarely captured before, that are just not within the purview of JCOPE, that should be engaged or at least solicited to get their feedback on, one, how they function, the practical implications, and also to make sure that we're comprehensive and most responsive in how we draft the guidance.
All right, well, given the fact that none of those organizations or institutions or companies contacted us, and you seem to, have given this a fair amount of thought, Dawn, I'd suggest that offline you give Martin a call so that you can make sure that the staff understands specifically who it is that you want to have contacted. Again, since none of these folks that you're talking about reached out to us, so we want to make sure that what you're thinking is is accommodated. So if I could ask you to do that, that would be great.
I'm happy to.
Great, thank you. All right, so unless there's any further discussion on the Lobbying Act advisory, let's turn to the proposed advisory opinion concerning reporting obligations under the Lobbying Act for consultants. Martin, are you going to take us through this? Is it you're going to take us through this, Monica? Or
Martin can address any questions that anyone has about the consulting opinion.
Right, so just to sort of frame this a little bit, obviously we put a draft out for comment. There's been quite a bit of attention to this proposed advisory opinion, particularly as it affects the media and First Amendment issues. I think the staff has taken those legitimate concerns about the First Amendment into consideration and have made a refined proposal for us to consider, a more narrow proposal, so that nobody here is suggesting that a garden variety telephone conversation between a reporter or an editorial board and a lobbyist or a consultant is necessarily considered to be lobbying. I think the intent here, and I'll let Martin address it, is that if you've got an organized lobbying campaign, and as part of that organized lobbying campaign, you engage the services of a lobbyist or a consultant whose purpose, in part, is to solicit editorials or public comment in media outlets, but really the editorial board. So the lobbyist calls up the editorial board and tries to talk the editorial board into writing something on the specific matter that the lobbyist has been engaged. I think that's the kind of conduct that the staff is thinking about. We're not talking about the editorial board calling informed people about a particular subject to ask questions because the editorial board, sua sponte, has decided this is an important issue which we need to address, or a reporter is working on a story. We're talking about somebody who's getting paid as part of a specific lobbying agenda to obtain favorable newspaper stories, or more importantly, editorials. I think it's because I think there's a big gap between one versus the other. But I'm going to let Martin address the comments that we got and the changes that the staff is proposing for us to consider in this advisory opinion.
Thank you, Mr. Chairman. You presented the issue very thoroughly and accurately. So obviously I can address questions, but I just want to point out with any regulation of lobbying, going back to the first Supreme Court case in 1957, I believe, there's always a tension between the protection of the First Amendment and the rights of the government the rights of the public to have access to the information about the activities of government, and that is the transparency that's required. So it isn't enough to say that asking someone to report their paid activities to influence the media is an infringement on First Amendment, because the Supreme Court has said up front for some 60 years now that is an applicable, or an appropriate use of regulation. That said, we are cognizant of this tension, and we're not looking to overreach in any way. And so we've added a footnote that to this opinion that would reiterate what you just said, and that is that this is not an intent to infringe on the First Amendment, but rather to generate the required transparency for those who are paid to attempt to get the media to take a position. And reporting on a story ostensibly is an objective effort, not taking a position. So this is not designed to address those scenarios. But that said, any situation that might or might not be captured is going to be dependent on the individual facts and circumstances. So it's difficult to say beyond a general statement about what the intent of the opinion is, how a particular scenario might be captured.
Right, and Martin, I want to open it up for discussion, but the obligation here, Martin, is not on the media outlet, it's not on the editorial writers, and it's not on the newspaper reporters, but it's on the lobbyist. Absolutely. And the lobbyist knows, I have been hired by the Acme company, who's interested in a piece of legislation that's pending in the state legislature. That lobbyist knows that he has been paid or she has been paid, and that they have a fixed strategy that includes trying to sway public opinion through the editorial boards. So the obligation is on the lobbyist, and it is a reasonable regulation of speech, which clearly the Constitution and the Supreme Court permits. Yeah,
and in fact, not only is the obligation on the lobbyist by virtue of this, what would be this commission's opinion, vis-a-vis an opinion, but the legislature has an existing exception in the Lobbying Act for news media for these sorts of situations. So there is no intent, nor is there any chance of the media being captured by this opinion, statutorily or vis-a-vis the opinion.
Marvin.
Good morning. I've asked this before. Perhaps you have an answer. In any other is there any precedent for this that has occurred in any other jurisdiction, federal, state, or local? Or are we writing on a clean slate here without any precedent?
To the best of my knowledge, let me back up for a second, Commissioner. Are you specifically talking about the application to these media entreaties by lobbyists to the media, or are you talking about the opinion as a whole?
The opinion as a whole, and I'm not saying this in any pejorative sense, I just seek the information as background.
Sure.
Whether we are on a cutting edge here, or we're just following some leaders in this area.
Sure, okay. The reason I asked you is that the opinion has a few discrete parts. So I'll address your question individually. With regard to the opinion section that deals with those who create access or do what we call door opening for a client, I believe we would be on the cutting edge as far as explicitly stating that this activity would be covered under our lobbying statute. That said, there are, I believe, 18 or 19 states that have what's called goodwill lobbying in their statutes, which could arguably be capturing this same activity. So I believe we would be the first to articulate it, but not necessarily the first to have the jurisdiction. With regard to grassroots lobbying, for laying out a definition of grassroots, we are far from the first to do this. We would be consistent with our counterparts. And then, as far as capturing the activities of consultants in those grassroots efforts, I haven't been able to find anything in a parallel jurisdiction that would cover this. So I believe we would be, again, out front in terms of articulating these arguments.
Thank you.
All right, and this is an advisory opinion. I mean, it is not a regulation. It is an advisory opinion, and there's a difference, as we all know. Anybody else have any comments or questions? Dawn?
Martin, how do you weigh the response from the media? There's been a pretty strong pushback from media organizations about this advisory opinion, and I'm curious to hear your response to that generally, or the specific concerns that they raised.
Sure. I think it varies in terms of the outlet and their responses. There were some very dramatic, I'll say. There were some very dramatic responses from certain media outlets that seemed to read this far broader than we had any intent, or I think any plain reading would lead you to. To the extent the concerns were a valid reading of the opinion, we welcome those, and in fact, we made a modification to address those. We think they're valid concerns, and we wanted to make clear what our intent was and what it wasn't. As far as how the media should view this, I think given the existing exception in the statute, maybe this is me just defending the work we've done, but I think the media might view this favorably because it's going to generate transparency about who the people they're talking to are being paid by. So if you're being solicited as a media outlet to take a position on an issue, I think you would want to know who's paying this person who's reaching out to you. But beyond that, I don't think it makes it certainly has no intent, and I don't believe any reading of this opinion would infringe on the media's activities in any way.
Okay, so your response is that they misunderstand.
In some part, yes, and in some part, their concerns were well taken, and the footnote that we added was in response to that.
Okay, so in one part, the media misunderstands, and in part two, the footnote adequately addresses the concerns by the media?
Yeah, I would say there were a range of responses, and the reasonable ones we took and addressed, and the unreasonable ones, you can't please everyone.
Dawn, let me ask you a question. Dawn, can I ask you a question in terms of the limiting footnote? I mean, as I understand the footnote, and I said it a minute ago, the idea here is that if you have a hired lobbyist who's got a strategy to try to sway a position pending before a government body or the legislature, and part of your strategy that you're getting paid for is that you're going to try to affirmatively and proactively reach out and get editorials, and this is something that we know, happens all the time. I mean, I'm curious about, do we consider that to be lobbying? And that's what this is about. So I think that's what the advisory opinion is about, and that's what the footnote is intended to address.
Might I suggest, Mr.
Sure.
Chair, that it not be a footnote? Seems too important to make a footnote, but I just throw that out there.
Well, I think that's to me, doesn't matter what the form it takes. I think that you're right. If your point is that it
Generally
has to be
speaking.
absolutely clear that we are not infringing the media's right to, do its business, but what we're focusing on are the activities of a lobbyist who gets paid to sway public opinion to advance a particular legislative or executive branch agenda. So can we put the, can we put the footnote in the body, Martin?
Absolutely.
Okay.
Then it'll be ready.
Yes,
Dan?
yes, Dawn.
Parking the media issue, the other kind of substantive point that I wanted to raise, and this may just be a point of disagreement, is about the standard of control and input into the message. So, I mean, there's a clear threshold when you are proactively making the contact or proactively issuing the call to action. But what we're also encompassing in this advisory opinion is a different kind of activity, which is even if you never leave, what I would call a black box, if you were an academic and wrote a legislative strategy and then went back to your office and never talked to anybody again, the way I read this advisory opinion, that person would be a lobbyist because they had a substantive input into an ultimate strategy. So this gets to the broad, how the standard of, I mean, you laid out a very clear standard where I think there would be broad agreement that that's lobbying. But on the other end of the spectrum is a consultant that provides, and again, I use the example of a professor or an academic who's not actually engaged in the broader work of lobbying or advancing issues, but has thoughts and writes a paper and says, this is what I think about this, and somebody takes it.
Dawn, can I just interject?
That person would be...
In your hypothetical, is the academic who wrote this paper getting paid by somebody to write the paper?
No.
Okay, so then it's not lobbying. That doesn't meet the fundamental definition of lobbying.
Let's just take it to a consultant. Let's take it to a consultant. Let's take it closer to a real life scenario. A consultant that is getting paid, who comes up with a graphic and a mailer and a message, or comes up with a strategy, never has contact with the client, never comes to contact with an elected official, is a lobbyist. Has no direct involvement with the contact, has no direct contact with the call to action, is a lobbyist. And so, and a lobbyist that needs to register with JCO. So, I think I have a problem with that line. I think that's challenging. And then I think that kind of moves over into the PR example that we're using here, that I think was at least some of the basis for some of the pushback that we got among the media.
Thank you, Commissioner.
Let's just, yes, Joe, but let me just get Martin to address the point that Dawn raised, and then I think we can advance.
Commissioner, I respectfully disagree with your reading. The opinion prescribes that in order to be required to register as a lobbyist, obviously you'd have to meet the expenditure threshold, but you would have to engage in the actual delivery. And a consultant who's purely behind the scenes, who never has contact with the public official or the public or the media or any other outside body, but only with their client behind the scenes, would not be captured. So I think your example of the academic, compensated or otherwise, is not captured by this opinion. And clearly we talked about this in the last meeting, that the existing standard, as the opinion was originally drafted, could arguably have captured those folks, and we took those concerns to heart. and said, we're not concerned about people behind the scenes. Well, not that we're not concerned. We'll get the disclosure through the expense reporting. Where we need the registration and the prohibitions on gifts and contingent fees are those folks that have contact with the public or the public official.
Any other comments?
Very good, Chairman Cavello. Any other comments or questions?
Maybe I've had it
Are we
too much
ready
coffee this
to,
morning. Let's go.
are we ready to take this advisory opinion up? Yeah, David?
Just one more from Martin. This is David Arroyo, and this has a question about having to do with delivery. So let's say that there is, it's not a discussion with an editorial board, but it's a discussion that the reporter is having with a consultant that was not initiated by the consultant, but rather was directed to the public official, and the communications consultant was provided as a reference to the reporter. And there's a discussion, is that activity captured? Is it assumed that that message is ultimately going to be heard and or received by a public official whose actions are intended to be swayed on a piece of legislation? I just want to better understand that linkage, if Martin could address it.
Well, not to
So
play.
that, I just described, would that activity pull that consultant within the ambit of this advisory opinion?
Not to play the appointee at the confirmation hearing, but it depends.
Yeah, maybe we should go down rabbit holes that, there's no coming back from.
I want to point out, this is obviously just it's an advisory opinion providing guidance to those governed by us about how we're interpreting the Lobbying Act with respect to defining lobbying. There's going to be lots of nuanced questions after, this is issued, if it's issued, and, this is what we do all the time, is staff gets these types of questions, and we'll have to answer them and provide additional guidance. And as we've also discussed, ultimately, we're hoping that once we knock out some of these issues, the consulting, social media, and a few other issues, that we will put together comprehensive regulations or revise our existing guidelines to include some of these things, and we'll learn over the next year about some of the things that we need to address. But we're not going to be able to answer every nuanced question in an advisory opinion, particularly when some of this is about one sentence in that advisory opinion that deals with a much more a complex issue. So I think a lot of these things are going to depend on the very specific facts and who's paying who and what part of the campaign it is and what the contracts and arrangements say. So it's hard to answer these questions in a hypothetical without real facts.
Yeah, just to state the obvious, and I understand that you're going to sort of get a lot of questions around this. I believe that that's part of the discomfort you're hearing in some of the, from the regulated community, is that obviously the fact that they're hired, one might infer from that the QED, anything that they say to the press, is meant to influence an elected official who has a piece of legislation before him or her, and if that's the message or the directive that we're providing, that we should be clearer about that.
But if I could interject.
That's not the case.
But that's not the case, though, David, because what the staff did was, and if it's necessary, it's in the book, the footnote, which Joe Cavello, I think, prudently suggested should actually be moved into the body, I think makes it abundantly clear that hypo that you just raised, where a reporter or an editorial board or a member of the press contacts a lobbyist to ask a question, and it happens to be in the subject area that the lobbyist has been retained we have carved that circumstance out of the advisory opinion and have limited it solely to the circumstance where the lobbyist initiates the contact, not the media, not the other way. It's where the media is the recipient of a phone call from a lobbyist who has been paid and is executing a definitive strategy to influence public opinion by seeking news stories or, more specifically, editorials. It is not your garden variety reporter picking up the phone to talk to a lobbyist they know and say, hey, what do you know about this? What's happening with this bill? That's not what we're trying to do here. We're not trying to limit the media's ability to pursue a story. What we're doing is when a lobbyist gets hired and that lobbyist, as part of their strategy, decides we are going to pursue favorable editorials on our issue, and as part of the paid service that lobbyist is providing, they, the lobbyist, initiate the contact with the reporter, with the editorial board, and they solicit an editorial. Hey, we're working on this. How about an editorial on this issue or that issue? That's what we're talking about. The public has a right to know, just as the lobbyist registers and discloses their activity with respect to members of the government. If you are being paid to lobby, the public has a right to know that. We're not talking about infringing or impinging or confining or constraining the media's ability to pursue the stories that they are well vested in pursuing. And the footnote, which we propose as part of the body, perhaps, Martin, maybe you want to, just read that into the record, because while it's in the proposal that we put in front of you, we've had, a number of commissioners appropriately asking questions about it. Let's just read it so everybody understands that this is what we're trying to do here.
Sure. This, for anybody who has the opinion, this is footnote 21. And it says, and I quote, "This is in no way intended to restrict a reporter's ability to gather information or to seek comment from representatives of advocacy groups as part of reporting the news. Rather, this is intended to generate transparency in the activities of paid media consultants who are hired to proactively advance their clients' interests through the media."
All right.
Right, but again, I understand that, Dan. What that does not say, and perhaps this is what's tripping me up, is that if the communications firm is contacted by the reporter, that would not qualify that communications person as a lobbyist, because he or she was not initiating the contact. That's not what that footnote says. I'm fine if that's what it's meant to say. My suggestion would be that it be stated more explicitly.
Well, David, that's not the only issue, though. I mean, if the person...
The determinative factor is who initiates the contact.
It's not. It's not, David. Why would that be the determinative factor? If I'm paid to lobby and you happen to call me before I call you, that's not a determinative factor.
So it's not just if I'm out initiating the contact with the editorial page of the New York Times. It's if I'm speaking to any reporter, even if I didn't initiate it, so long as I'm being paid,
Right.
then I'm a lobbyist.
Yeah, because a good lobbyist is going to get a call, figure out what it is, run out and get retained before calling back, I would think. It's kind of their business.
I mean, I think the important issue in this is always about who is a client and who is a lobbyist. And again, it's going to be what the consultant, in this case, is hired to do and what actually happens. And so it's not necessarily just about who calls who, because I certainly wouldn't want to suggest that there's some way around this by getting a reporter to call you instead of you initiating the contact. It's when it's part of a proactive lobbying campaign, and this is what you're being paid to do, is to get the newspaper to write a position piece. What the footnote makes clear is it's not meant to capture fact gathering. It's not meant to capture when a reporter calls the media consultant and says, I need a statement. You know, that's not what we're trying to do. We're not trying to interfere with reporters who are reporting the news or developing a story or developing an editorial on their own. What the action that we're trying to capture is when the media consultant is paid specifically to influence the paper and to get a position piece published, and they will know when they're doing that. And that will be part of the lobbying activities.
Yeah, no, I'm satisfied that this is not going to have a chilling effect on reporters.
But I don't think it says I don't think this says, Monica, what you just said. I mean, I don't read it to say that if it's part of a proactive campaign. What you just laid out, the criteria.
The sentence in the text is further, again, this is in the context of in grassroots, when what we're talking about in controlling the message and delivery, it's an example, and it's further, a public relations consultant who contacts a media outlet in an attempt to get it to advance the client's message in an editorial would also be delivering a message.
Right, and just to be clear, again, we're talking about page 9 of the revised draft. If you see the deletion, the original proposal said, further, a public relations consultant who contacts a reporter or editorial board. So the original proposal covered reporters and editorial boards in an attempt to get the media outlet to advance the client's message, would also be delivering a message. The staff is proposing deleting that sentence and instead replacing it with what Monica just said, which limits this to a lobbyist who is in contact with a media outlet in connection with an editorial. So it by definition now has limited and excluded conversations between a reporter seeking to gather information on a story they're working on about a bill or a proposal that the lobbyist has been engaged in, as opposed to, again, the lobbyist seeking an editorial. So it does cut out, as far as I can see, conversations between a lobbyist and a reporter. It's specifically focused on editorials.
But again, I think you have to look at the context of this and where it's coming up in the advisory opinion, and Martin, you could add to this and explain it, but we're talking about you have to have participate in actual delivery and have some role in the content, and this is just giving examples of that. But it's all in the context of a lobbying campaign where you're hired to participate in the lobbying campaign. Oh, I covered it.
Okay, so that's an important qualifier.
But my point is that's what the opinion says. Like, you can't take this sentence out of context and just read the sentence standalone. It's part of an entire opinion that is laying out all these issues.
Okay. Marvin has something, and then I have something else.
Go ahead, Marvin.
This is just, again, my point on process. The method of advising or guiding via advisory opinion is laid out in Section 94:16, and it contemplates a specific request. So then when there is an inquiry, and it is rather specific, 94:16 comes into play, and an advice is given via an advisory opinion. What we're doing here is we're just, without request of any specific sort, trying to cover the waterfront on political consultants. We can sit here all year talking about every nuance that might arise. Now, if you want to give guidance that way, do it. But that's a question for the commission. But if you want to write an advisory opinion, you're not writing one now, don't call it an advisory opinion. Don't exalt it to the status of 94:16 makes it, because that's an important distinction between guidance and advisory opinion, and distinctions in law as well. So again, I repeat that although you seem to have deleted these references in part, this is not an advisory opinion. It's going to bog us down if we go into these areas in a general way. We ought to deal with specific requests that come from the public. They're generally written, and we respond to them in advisory opinions.
Monica?
Thank you.
Yeah. Commissioner, just to clarify, we're not operating under 9416. We're operating under the Lobbying Act, Section 1D, which says that we can issue advisory opinions to those under its jurisdiction. And such advisory opinions, which shall be published and made available to the public, shall not be binding upon such commission, except with respect to the person to whom such opinion is rendered, provided, however, that a subsequent modification by such commission of such an advisory opinion shall operate prospectively only. So the language in 1D...
Same kind of provision.
Except it says we can issue advisory opinions to those under its jurisdiction. It doesn't have the same language upon request. But that being said, over the last several years, we have had many requests to address this issue and generally speak to this area of people who label themselves as consultants and when are they engaging in lobbying. So I just wanted to make sure everyone understood, though, we're not talking about 9416.
All right. Well, we've had a pretty thorough discussion. I don't know, Dawn, you had another comment?
Really?
Dawn Smalls?
Yeah, just on language, I would just pose to the staff, it says in the definition of grassroots lobbying that control of the delivery of a grassroots communication involves the participation in the actual delivery of the message. The way that's written, it reads as inconsistent. Control is not the same thing, just on a common sense reading. Control is not the same thing as participation. Control is control. So we need to figure out how to articulate that in a way that captures control, or say it's participation, or it's control, but control does not equal participation.
I think she's talking about,
It's on page 2.
Yeah, your comment is well taken, Commissioner. That choice of words comes from our predecessors in Opinion 39 of the Lobbying Commission. And in order to maintain consistency with that opinion, which I think we should, I chose to use the same rhetorical devices. And so I think what we've laid out has articulated what the elements of that standard are. And while I hear your concerns, that was the reason behind it. So obviously you're the commission and I'm just staff, but I wanted to give you the underlying, or the underpinnings rather, of that choice.
all right, well, we've had this out for quite some time. We've had a pretty thorough discussion. I don't know if folks want to put the question at this point. I'm not sure that there's going to be further clarification, and if there is, I'm not sure what anybody had in mind.
Weissman's waving.
Pardon me?
Weissman's waving.
George?
What are you waving at, George?
George, you want to be recognized?
Dan, do you need a motion to move this?
Yes, we, if folks are ready to go forward, then let's have a motion. George,
Consider it moved.
is there a second?
George is moving, I can't second it
George.
because I don't agree with anything.
Gary seconds. All right, let's take the roll. All in favor of the advisory opinion, raise your hand.
As written or with modification?
With the modification to move the footnote into the text.
What modifications, Dawn, other than the one that Joe proposed, which is, Monica
This is
said,
brilliant.
putting the footnote, it was. You've had your moment today, Joe.
That's it. I used up my chip.
Exactly. All right, no, so seriously,
How
to
come I
put
only
the,
have one chip?
Were
Right,
there,
to
were
put-
there any other
but
modifications?
were there any other changes that people wanted to make? I mean, if you have them, you can move to a,
Participation.
pardon me?
I think that needs to, I think control, the equation of control with participation needs to be addressed. I don't think on a common reading, understanding that the desire was to make it consistent with the prior opinion, on common reading, I don't think it works to say you control something if you participate in it.
Hold on a second.
But they want to be consistent with the others.
Well, I think that's the answer. Well, I mean, go ahead. I think the staff,
I mean, in
Dawn,
my
that-
view, it's, and Martin, I think you can explain, I think we explain how we're interpreting control as actual participation in the section on grassroots lobbying. It's beginning on page 7. We're explaining that further, so that, you know, obviously the shorthand that you're referencing on page 2, which again honors the existing precedent of this commission, which uses the word control, we are explaining that, what that means in the body of the opinion. I don't know what more you would want, but Martin, I don't know if you have anything to add on that.
Yeah, I think just to kind of, I don't know, offer a counter to your point about common sense reading, when you talk about grassroots communications, there's different elements of participation in the grassroots communication. So, as an example, if I'm a consultant behind the scenes and my client says to me, you tell us how to get this done, how to deliver it, you have carte blanche on how to deliver it, and I'm not going to argue with whatever you decide. And the consultant lays out a strategy, and the client executes it, but the consultant never speaks to anyone other than the client, you might argue that that consultant has control over the delivery. And what we're saying is, no, they do not. They have to engage in the actual delivery to be considered having control. And so that's, you know, just kind of a way of parsing the word, and I think the opinion goes through that.
Aren't we in the middle of a vote?
we are. So
Which she was just, that we were discussing whether or not there should be further
we're discussing whether
modification.
there's an amendment. Why don't we
I
continue?
just didn't understand if we were, it's fine, let's move forward.
All right, let's continue the vote. Everyone, all in favor of the advisory opinion, please raise your hand and keep your hands raised.
George, I can't see the webcast.
All right, let's, do you need a roll call?
Renzi.
Do you want a roll call? Yes. Let's do a roll call. Okay, we're gonna call the roll. Commissioner, when I call your name, please give your vote, yay or nay. I'm voting in favor. Commissioner Arroyo. Commissioner Arroyo, yay or nay?
What was that?
Yay.
Yay.
Commissioner Cavello.
Yay.
Commissioner Jacob.
I'd like an answer to my question before I vote, directed at Monica, which, from the statute she read, such advisory opinions shall not be binding upon the commission, except with respect to the person to whom such opinion is issued. To whom are we issuing this opinion?
Give him the same.
You read that provision as applicable.
Right,
You just read it to me 10 minutes ago.
I understand.
How do you answer that?
All right, let's continue. I think she answered it before. Let's continue the roll. We'll come back to you. Commissioner Knox, we're in the middle of a vote. Commissioner Knox, yay or nay? Yay. Commissioner Koretz.
Yay.
Commissioner Levine.
Yes.
Commissioner Renzi.
Yes.
Commissioner Romeo.
Yay.
Commissioner Roth.
No.
Commissioner Rosen.
Yay.
Commissioner Smalls.
No.
Commissioner Weissman.
Yay.
All right. Currently, the vote is 10 in favor and 2 opposed. Marvin will have the staff try to attempt to answer your question one last time, and then you'll just have to vote so we can close this out. Monica's gonna, I think, just checking the statute, and she'll give you an answer in a moment.
Just want to make sure this is binding on us.
I know, that's my own thing.
It's not binding on us.
I mean, I would argue we put it out there and it's binding, but
Okay, so just, I'm going to try to answer this,
it's
Marvin.
about whether it's binding on the commission, and I would argue that the opinion is binding.
It's, look, we have had this discussion on a number of occasions about advisory opinions, and you have, as always, to borrow the phrase from another commissioner, cogently explained the position that you think that advisory opinions have a limited precedential value. The staff has explained that they have a different view. There are other commissioners, including myself, who have a view that there is precedential value to the advisory opinions, to the extent that if we ever move forward with an action, the advisory opinion doesn't have the same force and effect as a regulation, but the advisory opinion can inform an evidentiary issue as to whether or not a potential violation was done with the requisite intent. That is to say that somebody was on notice that there was an advisory opinion, and then took an action that was inconsistent with the advisory opinion, along with other evidence, would establish that the alleged wrongdoer acted with the requisite statutory intent. So, I mean, we can have this discussion again. We are in the middle of a vote. I don't think that there's going to be an answer that Monica's going to give you that's anything different than what she has explained already today a few times and ad infinitum at other meetings. So I'm sorry that if we can't give you a clearer answer, I'm pretty confident that Monica has given you her best answer. And so now the vote is to you, and we can take this debate up, you know, this sort of existential debate up at another point. The motion is on the floor. Are you in favor of it, or are you against it?
I will register my vote as a no vote, as did Commissioners Small and Roth.
Okay. Thank you very much, everybody. The motion carries, 10 votes in favor, 3 votes against. The advisory opinion as amended with Commissioner Covello's amendment is adopted. Thank you for a thorough discussion on that. All right, we now have a third advisory opinion that we have been discussing concerning campaign solicitations by elected officials. We've gotten some comments to the extent that we want to discuss what those comments are, and then have some discussion on the matter if we can. Let's do that at this point. So Monica, I'll turn it over to you.
Sure. There is a proposed advisory opinion before the commission with some revised language that's suggested for consideration. While staff doesn't believe that the changes are necessary or in any way really change the substance of the guidance that we're providing, it's an attempt to either clarify issues and questions that have been raised in comments that we've received, or it addresses some concerns that have been raised by some of the commissioners. As many of you know, we received comments the other day from the Attorney General's office. Those have been circulated to the commission, as well as posted on our website. The Attorney General is suggesting that this is an attempt at campaign finance reform, which is outside the commission's authority, and he argues that it's that the opinion unfairly targets his office and the Office of the State Comptroller, who engage in more enforcement actions, and that it unfairly discriminates against incumbents as opposed to candidates. Notwithstanding the fact that this is an interpretation of the Public Officers Law, and that state officials who hold elected office are subject to the Public Officers Law, and that's really what we're doing here, is interpreting Public Officers Law in a particular context and how it should guide their actions. So that's where we are.
All right, and then were there some proposed, after our last meeting, just again to highlight for the commissioners, although it's in the book at tab E, Were there, based on other comments, were there changes that the staff is recommending to the draft that was in front of the commissioners at our last meeting? And if there
Yes.
are, can you discuss what those are?
I mean, there are, the majority of the page changes to the language are on page 4 and 5. Among other things, on page 4, we were suggesting some language to clarify the policy behind the decision and the law that we're trying to enforce, which again is the public officers law, and that it requires for violations knowing and intentional action. These were in response again to some of the comments that we received, questioning how we're going to apply this guidance. In addition, we are incorporating language that came from the city bar, which, while the city bar acknowledged it wasn't necessary to add this clarifying language, we agree that it might be wise to do so to just make things more clear. And so we made it clear that when we're talking about the enforcement action, we're talking about an elected official and whether or not they should be soliciting from someone. The enforcement actions we're talking about are those in which they have personal and substantial, whether they or their immediate staff have personal and substantial involvement. So again, we took up the city bar's recommendation to include that language. Like Commissioner Covello suggested in the other opinion, we moved from the footnote into the text, the definition of enforcement powers, to make it very clear that's what we meant. And in response to some concerns raised by some commissioners, we deleted the definition of elected official that was in footnote 4, and instead are just referring to our authority under 9416 to provide guidance.
Is this the one that LEC weighed in on? You got a letter from them?
We received letter from LEC before the last commission meeting, and we circulated that letter to the commission.
But I think Joe's question is this
Oh.
most recent change that
It-
you just described, among others, it was the LEC that raised this concern.
Yes, thank you.
And the staff is suggesting that that was a change that they would propose to the full commission. So the answer to the question, Joe, is yes. Commissioner Levine?
Mr. Chairman, I would ask your indulgence in permitting me to reserve my...
Speak louder, please.
Yes, of course, Judge. I was asking the Chair's indulgence to allow me to reserve my comments to an executive session, as my comments relate directly to an investigative matter.
Okay. I think we can do that.
Will it be delivered cogently?
Yes. So, unless there's any further discussion, I'd like to.
Dan?
Yeah. Yes, George?
Couple of questions for Monica. First and foremost, what elected officials are impacted by this proposed advisory opinion?
Well, clearly, the 4 statewide elected officials are impacted. I think there's been a debate among the commissioners, as raised by LEC, about whether or not JCOPE can provide guidance directly to other elected officials. And so, while I think that, sorry?
Monica, a question. Who does it apply to?
Well, I'm trying to answer your question, George. I'm trying to say, I think that,
Well, hold on, George. Please, George, just let her finish, and you can ask a follow-up question. Go ahead, Monica.
well, I would suggest that, all elected officials could read this guidance and be aware of how we're interpreting Executive Law Public Officers Law 74. At this point, we're not directly providing guidance to those elected officials.
Which elected officials are we talking about?
What did you say?
Which elected officials?
are we talking about?
The legislative members?
No, so,
Monica,
he
I
wants
have
to
a
know,
number.
does this...
I thought I said that. I said
No,
it directly applies to the 4 statewide elected officials.
That's it, George. That's your answer. It applies to the 4 statewide electeds. If members of the legislature want to follow this advisory opinion, they can do that. But this is not directed at them, and that's why, in response to, among others, the LEC's comments to this draft advisory opinion, the staff has proposed the deletion that Monica referenced. So does that answer your question, George?
In part, Dan, my suggestion to the footnote that was added is that we explain what 9416 says. To the first part of it, which Monica was reading before, and then there's an exclusion. That's the first recommendation I
All
would
right,
make.
that certainly makes sense to me, and we can talk about that, but that makes sense to me.
Then the next one, Dan, goes to enforce what we have defined as enforcement power. First of all, I think all the verbs should be active. So you're actually in a position where there could be an appearance or a conflict. So you have subpoenaed, not the authority to subpoena. Maybe this is consistent. This may or may not be consistent with what the Attorney General said, but I think it would make it much more clearer. And I guess I may have to actually say I probably agree with his position on attempting to change the campaign finance rule. So it's not the authority, but it's the actual use of the power. Additionally, under enforcement power, we use the term investigate and prosecute, but the examples are disjunctive, not conjunctive. So I think that has to be taken up. And finally, and I have a question to Monica as to what the last sentence actually applies to in that sentence.
Conclusion, that sentence?
I'm sorry, wait.
Excuse me?
Conclusion?
The last sentence says it does not include the authority to regulate, supervise, or license.
Let's see,
What page you on,
What's
George?
being called that?
George, what page you on?
He's talking about the definition of enforcement powers on page 5.
Oh, okay, okay.
The mere ability, what the sentence means is the mere ability to regulate doesn't necessarily mean that there's an ongoing enforcement action. So, for example, right, the Attorney General's office regulates co-ops. That doesn't mean that every co-op is the subject of an enforcement action. They regulate charities. That doesn't mean that every charity is the subject of enforcement action. And as I think is clear in here, we're not talking about potential subjects, we're talking about actual subjects of ongoing enforcement actions.
Is there some reason then you required you would require an active enforcement under that sentence and not above it?
I'm sorry, I don't understand your question.
Well, it seems as I understand what you just described, just because you have the authority doesn't mean that this is an enforcement power. The power, for example, let's use DFS, for example, Department of Financial Services. Just because you have the power to set insurance rates, that it doesn't affect for-profit insurers who could be giving campaign contributions. Is that correct?
Unless they're the subject of an ongoing enforcement action.
But above, you don't have ongoing. You just have the mere authority. You sort of just, you've broken it up in a way that I can't understand.
I understand, George. That's just the definition of the term, but in the paragraph that precedes it, it says, which is the active subject of enforcement powers of the official or the official's office. And now we're just defining what we mean by enforcement powers.
Well, they do have to define it much more clearer. You know.
Well, how?
And I think.
I guess we.
And I believe. Dan, let me finish.
Yeah, sure. Go ahead, George. Sorry.
I'm sorry. I believe in that last sentence there should be an admonition to people who regulate, supervise, or license that they avoid areas of conflict of interest or appearance?
Well, let's take the first issue, which is, it seems that the heart of the advisory opinion is the first paragraph on page 5, which says, Public Officers Law, Section 74, prohibits a state elected official from directly soliciting or accepting a monetary or in-kind campaign contribution from a person or entity which is the active subject of enforcement powers of the official or the official's office, in which the elected official or the official's immediate state staff are personally and substantially involved. So that, if you would, that's the action part of the advisory opinion. And that's what, you know, the opinion is advising people who are actively conducting, you know, or involved in an investigation of somebody who is an active subject of an enforcement powers. I think what Monica's trying to explain is that you have to define generally what enforcement powers mean so that we're talking about the ability and the authority to actually conduct an investigation and prosecute an alleged violation of the law. And by prosecute, I don't think that necessarily means prosecute in a criminal sense, but it means prosecute an action. So I don't think, and I understand what your concern is. I mean, I understand that, you know, that this, I think I understand your concern is that this should really just apply to situations where there's, you know, a live investigation of an active subject. And the definition of enforcement powers, I think, is intended to, you know, circumscribe the kinds of activities in which there can be an active subject. So it's not, you know, your garden variety regulation, it's not, you know, other government functions. Enforcement power has a specific meaning. So when you say, George, that you want to define this more clearly, you know, I understand what you're, I understand the issue that you're getting at, but I'm, you know, I think, and Monica expressed it too, just curious about, well, if you're going to talk about enforcement powers, the active exercise of enforcement powers, how do you go about defining enforcement powers?
Well, we have it here. I think we have it here. But I just think the verb should be active. So refers to investigating or prosecuting alleged violations.
I see. So, or you could say which is the active subject of an active exercise of enforcement powers. In other words, what you want to make clear is that you have both an active subject and that there's an active exercise of the enforcement powers. Is that what your concern is?
Yes.
Okay. All right. So we can.
And I think that's a concern that's raised by others.
Yeah, I'm with you, George.
All right. So we can.
The term enforcement powers refers to active.
Or you could say which is the active subject of ongoing or active enforcement powers. Or active or an ongoing exercise of enforcement powers. Active subject of an ongoing exercise of enforcement powers.
Okay.
Does that?
And then you want to turn the definition into, you want to say enforcement powers refers to investigating or prosecuting alleged violations of laws.
Yes, and then everything else after that, so it would be not limited to the power to issue subpoenas, but issuing subpoenas, auditing books of records, all active verbs, compelling.
It's fine. That's, I mean, I don't.
And just change the end to an or instead of an and. I got it. Okay.
It's inconsistent, Monica.
Okay.
All right. All right. So I mean, unless other commissioners have comments about that, I think that sounds like the staff can make those changes. I certainly have no issue with them. I think they're good. They're good. They're good changes.
Just a question. I agree with everything George has said, but how do you read this in the disjunctive or in the conjunctive? Is it investigating and prosecuting or prosecuting? So how does the definition now read?
I think based on Commissioner Weissman's suggestions, it's going to read or. And in the list that follows, enforcement powers include, it will end with or initiating litigation or an adjudicatory proceeding on behalf of the public.
Thank you.
And Commissioner Weissman, are you okay now with the last sentence, or are you suggesting a change to the last sentence as well?
Well, I don't know if anybody else sees the issue that I see. That it seems, I'm just not sure what we're getting, what we're carving out. That seems to be, that I'm having, you pointed to the areas of the Attorney General, obviously areas that you're familiar with from your time in the Attorney General's office. But there are a number of, the Department of Financial Services comes to mind with me because they do a lot of rate regulation, they do a lot of supervision, there's licensing, and so I just want to get a better handle, really, on
In other words,
make sure.
why is the carve-out necessary once you have amended the definition? If you deleted the carve-out, what do you lose? These people don't do, if they're not doing anything of an enforcement kind, so you don't need the carve-out. The carve-out is investigations of prosecutions of lawsuits. They don't do it. They're regulating, supervising, whatever. But once you fall into the enforcement definition, there should be no confusing carve-outs that follow.
I believe the language was added based on concerns that were raised, but it's just a clarifying sentence, and I agree, it doesn't really change. I believe that the sentence was originally included based on discussions that I had with the Comptroller's office and the Attorney General's office initially, and their concerns that, that potential subjects weren't going to be included, and that the entities over whom they oversee on a regular basis wouldn't necessarily be included. But again, it just clarifies our position. It doesn't alter it in any way.
Dan, I guess I'm coming around to where Marvin is. I'm not sure exactly what it adds. It could add a point of confusion because the overall tenor of the opinion tells the statewide elected officials to be mindful of the actions that are occurring in government when they're out doing campaigns, when they're out raising money.
All right, George, I mean, I understand yours and Marvin's point. I mean, I don't think I have an issue if you think it's superfluous, it doesn't need to be in the advisory opinion.
I have one more question.
Marvin, I just want to make sure George heard my last, because I think I trailed off. I don't have an issue if you guys feel it's superfluous and that sentence needs to come out.
I don't want anything to really undermine what we're trying to do here.
I understand. Marvin?
And the other thing I'm going to ask, Dan, Marvin, would you beg my indulgence for a moment?
Of course.
On page 4, in that new language, Monica, I'm just quickly looking at it, and we talk about, I don't know if we need to do this, we talk about their investigative and prosecutorial authority. If you believe the and is appropriate, that's fine. If you believe or is a better term, please use it.
That's fine. I think we'll be consistent throughout, and now that you're raising this, I'm just double checking at the very beginning. No, we don't explain what enforcement powers are, so I think it's fine.
You do, okay.
Okay, so I think that's fine, just to change that sentence, just so everyone is clear, we're talking about the third highlighted sentence on page 4. Elected officials' power is never more potent than in the exercise of their investigative or prosecutorial authority.
Okay. All right. All right. Marvin, Marvin?
Thank you. Yes, as I understand it, the Attorney General's comments state that he and the controller are the targets or the subjects of this advisory opinion, that it applies to him and the controller and no others. Now, I understand your statement about the legislature has no application to them, but how does it apply to the other two statewide elected officials? How would it apply to the governor or the lieutenant governor? You said it applies to the four statewide elected officials. I assume that means the controller, the attorney general, the governor, and the lieutenant governor. Just explain to me how it applies to the latter two.
I think the language, I mean, I understand your question, but I think the language speaks to itself. To the extent that there is personal or substantial involvement by the other two statewide elected officials or their immediate staff, then this would apply. It's personal and substantial involvement in, as we're saying now, an ongoing enforcement power.
Let me just show. I'm just asking, what investigations of prosecutions of lawsuits take place in the governor's office? What are you referring to? I have no idea. Isn't the Attorney General right? This applies only to him and to the controller, unless you say that if DFS is conducting some investigation and somebody contributes to the governor, then the governor is implicated in this opinion. How do you reach the governor? Would you tell me that?
Gary?
The Attorney General's assertion, as you characterize it, Marvin, is just wrong. This opinion would certainly apply to the situation in which the Inspector General reports by statute, as I understand it, directly to the Secretary of the Governor. Applies right there.
That's in the statute. That's in.
Okay, you're answering my question.
Yeah.
I appreciate the answer, but the other part of that is that if the Inspector General is conducting an investigation, and there are many inspectors general, then the subject of that investigation would be inappropriate, improper for campaign contributions from that subject to go to the governor or the lieutenant governor.
If there was if there was personal and substantial involvement. And by the way, that's the same standard that applies to the Attorney General and the Controller. Standard is, and this was the language that was proposed by the Government Ethics Committee of the City Bar Association. We received a letter from Benton Campbell, who's the chair of that committee. I believe he was also at some point the United States Attorney for the Eastern District of New York. And their proposal was that the advisory opinion include this language on personal and substantial involvement as a way of circumscribing some of the concerns, among others, that were raised by the Attorney General and the Controller. So I think that hopefully answers your question. Gary, I think you had said...
I'm not disagreeing with you. I'm asking for clarification.
I think we've had... Okay. Hey, look, I think this is another one of these questions. Go ahead, Marvin.
I'm just asking whether it would apply only to an Inspector General's investigation. Would it apply if there was personal and substantial involvement to an investigation by DFS of the banking industry?
I don't know, Marvin, because it's an advisory opinion, and as as we've discussed, they depend on facts and circumstances. If there's personal and substantial involvement, then perhaps it applies. In any event, these are all, as always, very good and thorough and thoughtful questions, but I do believe, just for the sake of time, and I know I want to accommodate what you want to do, and I also understand that Commissioner Levine has some issues or questions or matters that he'd like us to consider about this advisory opinion that he feels have to be taken up in executive session because of some connection to an investigation. So what I would propose, again, for this, in the interest of time, and we have a full agenda, is that we take up this matter. I'll entertain a motion to go into executive session. That will give Commissioner Levine an opportunity to raise his concerns or issues. We can talk about it, and then conduct the other business that we need to conduct in executive session pursuant to Executive Law, Section 94 and 9419B. Go through our executive session agenda, and then take this matter up if we have time, and to the extent that we have time. I know we had on the agenda, a proposed regulation, but to the extent that we have time at the end of our meeting, we can take those up. So if that is acceptable to everybody, perhaps, we would entertain a motion to go into executive session so we can, along the lines of, so we can continue the agenda along the lines of what I've just proposed, if that makes sense to folks. Commissioner Smalls?
I don't have an objection to the suggestion that we move to executive session. I just had one more question about the proposed advisory commission that I did want to ask in the public session,
Sure.
Which is in the Attorney General's letter, he outlined I'll capture it as the difficulties with implementation, so the integration of government staff in making these determinations. I'm fully supportive of the goal and the language of the advisory commission as drafted, so also share other commissioners' comments about wanting to make sure it has as broad applicability to the statewide officials as possible. But I think just knowing how both government and campaigns work, he raises a very valid concern about how it would actually be implemented. And I'm curious to get the staff's response on maybe the answer is that's not within our purview to worry about how they do it, but I'm curious to hear what your views are or response, because I do think that's a very valid concern and valid point.
Well, I think you hit it on the nail at the last sentence that you said. I don't think it's within our purview to tell them exactly how to do it. And I do think it's perfectly appropriate for them to use Attorney General staff to fulfill the purposes of the Public Officers Law, which is to avoid conflicts of interest. And the manner in which they determine to do it is for them to figure out what is the most effective and efficient way. And again, it's limited to matters in which the Attorney General and immediate staff have personal and substantial involvement. And it's also my understanding that the office has vetting procedures in place. And so I'm not really sure how this really extends the existing vetting procedures in a meaningful way. We're just clarifying where we think there are potential conflicts that they should not be soliciting from the subjects of certain matters. So. But at the end of the day, again, this is just guidance, and the offices are going to have to figure out how to implement it if they want to follow it.
Thank you.
All right.
Dan,
Yes, George?
one more, before, since we're going to executive session, one more thing is when this opinion is finalized, and it sounds like it's going to be finalized in the executive session, that we send it to the LEC, because the legislature should also be looking at this question separate and apart from us. They've carved that out with the governor on separation of powers matter. So I think that this would be instructive for them.
All right, I think that's a good idea. I think that's a good idea. All right, so is there a motion then to enter into executive session pursuant to Executive Law 94, 19B?
So moved.
Second. Judge Roth. All in favor, Judge Roth, all in favor of going into executive session, raise your hand. All right. Any opposed? Seeing none, the motion's carried unanimously. So at this point, we're going to enter into executive session. When we complete our work in the executive session, we will come back to the public session, and to the extent that we are permitted by law to summarize or disclose the actions that we've taken in executive session, we will do so. So at this point, we'll enter into executive session. All right, we're now back in the public session. During our executive session, pursuant to Executive Law, Section 9419B, we took up a number of matters that were required by law to consider in the executive session. We considered a number of personnel issues. We had a litigation update from our counsel. We considered and granted an exemption from the revolving door provisions of Public Law 73, Section 73, 8-B. We approved a settlement of a substantial basis investigation. The commission also approved the substantial basis investigation report. The commission opened a substantial basis investigation, and the commission undertook a discussion of several investigative matters. And at this point, we can return to the discussion that we were having on the proposed advisory opinion concerning campaign solicitations by elected officials. Is there any further discussion or any motion on that?
I move adoption.
With the changes that were discussed at the, in our earlier public session,
Yes.
principally those that were raised by Commissioners Jacob and Weissman. Is that?
Yes.
Yes? All right. Is there a second for that motion?
So moved.
That's, was that George? All right, all in favor of the motion, raise your hand. I think we better take a roll call.
Can you repeat the motion, please? I'm sorry.
Gary, it's your motion.
Yeah, move to adopt the opinion with the amendments that were suggested in the discussion in the previous open session.
Just to clarify, it's the opinion regarding elected officials and when they solicit
Yes.
campaign contributions.
All right, so those in favor of the motion, can you just keep your hands up for a moment so we can make sure that we have a full vote?
I knew what was going on.
All right, it's going to be. All right, is there, do we have everybody? All right. Are there,
Did Rainey vote?
Not
No.
yet, no.
are there any opposed? The ayes can have their hands, put their hands down.
Ayes, yes.
Okay, any opposed?
Okay.
All right, I just want to confirm that that was a unanimous vote, is that correct?
Rini didn't.
Yes, she did.
She did, okay. All right, the motion is granted. Thank you, everybody, and again, thank you for valuable contributions by everybody on that. Unless there's further business for the commission, I will consider a motion to adjourn our meeting. Joe moves, is there a second?
Second.
Gary Levine, all in favor of adjourning, raise your hand. Any opposed? Seeing none, we are adjourned. Thank you, everybody. Remember, the staff will be contacting you for some dates for the second week of October.
October.
Yeah.
Second week of October.
Second week of February, sorry. Thanks, everybody, we're adjourned.